Fox Oldies, 98.9, 105.3, WGNY FM. On a fun day Saturday morning, I'm Bobo with very special guest and partner in a big, terrific law firm, Megan, elder care attorney. How are you, honey?
I'm great. How are you, Bobo?
Oh, just wonderful. And what a peaceful holiday season we had.
Yeah, absolutely. I feel very blessed that we haven't had any catastrophic events. We were able to enjoy it.
Oh, good food.
Mm-hmm.
That's where it's at. Made beef Florentine.
Oh, okay.
Yeah.
You made it yourself?
Oh, yeah.
Oh, good for you. You must be a wonderful cook.
I love to cook, Megan. I really do.
Yeah.
So you know what? Before we
great.
go any further in this brand new year of 2026, because I know there's been changes made in the state of New York to last will and testaments, before we do that, how about your contact information?
Sure. So I'm at the law firm of Blustein, Shapiro, Frank, and Barone. We're located primarily out of Goshen. The phone number here is 845-291-0011. And we have a really great website. It's www.mid-hudsonlaw.com.
All right. Did you already have that workshop video deal?
The webinar is coming up next week, actually, on the 27th. So because it's a webinar, there's unlimited amount of space. Anyone who's still interested can still sign up right on our website, and it'll be done through a Zoom link. You'll get it to your email. You click to enter when it's the day, and then you just listen in.
Yeah, because it's been really cold, and now we're expecting a huge snowstorm. Oh, man. I can't believe that. So here we are in a brand new year, 2026, and I know there's been some changes made to last will and testaments, et cetera, in the grand state of New York. So can you tell us about them?
Sure. So just a couple of updates, and keeping in mind that a lot of times these changes really occur over the first few months in the year. So we can see legislative changes throughout the year, but usually it's the first couple of months that we see those things finalized. And mostly at this point in the year, we're going to see changes to some of the tax rules, and specifically for estate planning, what people are usually worried about is going to be estate taxes. The good news is that a lot of people don't have to worry about estate taxes because there's an exemption. There's an exemption to New York State's estate tax and the federal estate tax. And what that means is that if the value of your estate exceeds the exemption amount, then your estate would be subject to an estate tax. But if it's below the exemption, your estate doesn't have to pay any estate taxes upon your death. So the changes that we're seeing for New York State is that we're seeing the exemption increase a little bit. So New York State's exemption is $7.35 million per person, meaning if your estate is over the $7.35 million, you'll be subject to estate taxes. But for most of us, myself included, if you're below the $7.35 million, you don't have to worry about any estate taxes. And then federally, that number is a lot higher. It's $15 million per person.
Whoa.
So if your estate is under the $15 million mark, you don't have to pay federal estate taxes either.
Boy, I'm relieved about that one.
Right? Squeaking by.
Yeah, right? I'll tell you, now that's really something else. So now, if what are the exemptions with estate taxes, Megan?
Yep. So those figures, like we said, they're going to adjust a little bit each year. There was some legislation at the end of 2025 that really fixed the federal exemption to the $15 million mark. If they didn't make those changes, we were going to see that federal exemption drop down a lot lower, but not incredibly low. It was still going to be close to New York State. So for most people, they don't have to worry about estate tax because if they're not above the $7.35 million, they don't have to worry about state or federal taxes. And what that does is it frees them up to do different kinds of planning, and they can focus their planning on asset protection for long-term care costs and capital gains tax planning, things of that nature. So it's a good thing because it just takes something off of most people's plates, and that's one less tax that they have to worry about.
So if somebody inherits $1.5 million, they don't have to worry about that, right?
That's right. So there's not going to be any estate tax taken from that $1.5 million before it gets to the beneficiary. And that's really where the tax happens. It gets taxed from the decedent's estate before it goes to the beneficiaries. So while it would, if you were subject to it, it would reduce the value of the estate and the amount that's being distributed, but it's not like any one beneficiary is responsible to pay the tax.
Well, what's the deal with capital gains tax, Megan?
Sure. So capital gains taxes, and for those people who aren't sure what that means, or maybe you've heard it but you're not exactly sure how it's applied, capital gains tax is a tax on any earnings or gain or appreciation on an asset at the time you sell the asset. So a good example of this would be stocks. If you bought stocks at $10 a share and you hold on to them and the market does well enough where now it's worth maybe $100 a share, and you say, okay, great, it's worth $100, let me sell it so I can cash out and keep my earnings. When you sell it for $100 a share, the difference between what you bought it at, that's the $10 per share, that's your basis, and what you sell the stock for, that's going to be taxable gain. The government's going, wait a minute, you made some money on this, I want tax from that. So they're going to tax you on that $90 per share difference. And the capital gains tax is really going to depend on how long you've had the asset for, but I would say the maximum rate, I believe, is around 28%. So it's a hefty tax if you do have to pay the capital gains taxes. But for estate planning, because we don't have to worry about estate taxes so much, we can actually do some planning for capital gains taxes so that when your assets, even the appreciated ones, pass to your beneficiaries, they don't have to pay the capital gains taxes.
Oh.
So through a little bit of strategy, we can make sure that we're wiping the slate clean, leaving the assets to our beneficiaries with no capital gains tax.
Well, here's another hypothetical scenario, Megan. So you inherit a home. That's all paid for. And the home was originally purchased for, let's say, $75,000. And the home has just been appraised for $500,000. What if you sell that? Is there a capital gains on that home?
So if the owner of the home, the one who purchased it originally, if they sold it, right, then their gain is going to be the difference between the $75,000 and the $500,000, so $425,000. Now, there's some sort of nuances when it's someone's primary residence. They do get an exemption on some of that gain. The exemption is $250,000 per person, or $500,000 of gain can pass tax-free if it's a married couple, and that's on the sale of a primary residence. But let's say now that instead of the owner selling that house, they hold on to the house for their whole lifetime. They pass away owning that home, and then that home passes to their beneficiaries, either through their will or their trust. When it passes to the beneficiaries, it doesn't matter that the original owner only paid $75,000 for the home. When the beneficiaries get that house through the inheritance, it's as though they paid $500,000 for the home. So if they turned around and sold it for $500,000, they would have no capital gains tax to pay on it. That property gets an adjusted cost basis. It gets bumped up to the value at the day the original owner passed away.
Oh, wow. So that's kind of a big break right there, right?
Absolutely, and that's one of the reasons that we try to discourage people from gifting assets to their children during their lifetime as their estate planning strategy. Certainly times will come up where you want to give things to kids or other people that you love or care about, and that's okay if you are wanting to make those gifts, but I don't want those gifts to be motivated by hurry up and get this asset out of my name because I think it will help me for tax purposes or long-term care Medicaid purposes or some estate planning focus. Usually by gifting assets to kids or other individuals, we can be doing them a disservice, and capital gains tax is one of the places that happens.
Wow. I mean, that's really Really excellent information, Megan. How about giving us your contact information again?
Absolutely. So the phone number here is 845-291-0011. The website where you can sign up for those workshops is going to be www.mid-hudsonlaw.com.
All right, so to reiterate a little bit on this, so when somebody passes away and they leave $2.7 million in a gift to the recipient, they don't have to pay any capital gains tax on that, correct?
The recipient does not have to pay capital gains tax as long as that asset, whether it was real estate, investment accounts, cash you don't really have to worry about as much, as long as the asset that passed from the decedent to the beneficiary passed through their estate and was includable in the decedent's estate, which for most of us that will occur. In order to remove it from their estate, they'd have to do some strategic planning. So for most people, when that 2-point-whatever million passes to their beneficiaries, it will not be subject to capital gains tax when the beneficiary liquidates that item.
I see. So let me ask you this question. So someone passes away and leaves a lot of assets to a specific individual. How long does it take for that last will and testament to be looked at and cleared so that person may receive all those gifts?
Sure. So that's a great question. So when we're talking about assets passing through a will, the process for that is actually known as the probate process.
Right.
And to back us up a little bit, the only assets that will pass through the probate process are going to be assets that the deceased individual owned in his or her name alone at the time he or she died. So there was no joint owner on the asset, on the bank account or the real estate, and there was no beneficiary designated on that item. So this is now kind of a loose end. Imagine the Megan Conroy bank account at a local bank. I never add a joint owner. I never add a beneficiary. When my family goes down to the bank to say, okay, Megan has passed away, here's a copy of the death certificate, we'd like to collect these funds, the bank is going to say, that's all well and good, but I can't give you this money, right? There's nothing that tells me you're entitled to these funds.
Oh, wow.
So they have to hold on to them until someone is given authority by the court. So the probate process is the process by which my loved ones would get authority from the court to collect my individually titled assets. And that process, the probate process, usually takes about a year from start to finish.
Oh.
That doesn't mean that the account is off limits for the whole year, but it will be off limits for the first several months.
So that means the individual that stands to inherit monies, in this particular case, can still take monies out of that account or not until the whole will is probated?
So they can't take money out of the account, but what will happen is once the will is probated, the court, through the probate process, will appoint an executor, whoever I've designated in my will, assuming they want to serve. The executor then goes to the bank and says, okay, here's the court documentation. They said, I'm trustworthy. I can collect these funds. It doesn't mean the executor gets to keep the money. What they have to do with it is put it into an estate account. And they're going to do that for each of my assets that I owned in just my own name. They're going to compile those into an estate account. And then they have to hold on to them for a little while because they have a responsibility of making sure that all of my debts are first paid. So if I had any lingering credit card bills or hospital bills or a Medicaid lien or anything like that, they have to make sure those funds are used to pay those debts first. And then if there's anything left over in the estate account after that, they look to my will to see who I wanted to share in those funds, who my beneficiaries are. And the court oversees this process to make sure that the debts get paid, and then ultimately my beneficiaries get their share of the inheritance. And that's a lot of work. So the executor is typically entitled to a commission, which is set by state statute, the amount that they're allowed to receive as payment for all of the work that they're doing.
Wow. Now, I know I've talked about this before to you, and as an example, I have a lifelong friend. Her name is Cindy, and she lived next door to me since 1958, and I'm still in contact with her, which is absolutely a wonderful feeling. But her father, without telling his daughter, he had a reverse mortgage on the house. Ooh, not good, because what happened is that she had to hire an attorney in order to sell the house. And it really made her jump through fiery hoops. So what can people do about this?
Well, I think that people want to be careful about the debts that they incur. Certainly sometimes something like a reverse mortgage, a lien against the house, some kind of line of credit, sometimes it's unavoidable. Certainly if it is something that you have to do, because you have to live, right? So somewhere you need to be able to get the funds, but you should understand what the repercussions of those loans and reverse mortgages are, what it's going to mean for your loved ones after you pass away. And because of all that, you should have a conversation with your family to say, here's the state of things. This is what I have, but these are the debts that I have. This is what you'll be expected to do if those debts still exist, so that people are at least prepared. They understand what it is that they're going to be getting into. In New York State, you are required to have an attorney to help you through a real estate sale. That's not true in every state, but New York it is. And it's actually a good thing because the attorney is there to protect you, make sure that the contracts you're signing are a good deal for you. There's no sneaky provisions in there. So it's good to have an attorney, but it will mean that there's a little bit of expense associated with the sale. So for your friend Cindy, not only did she pay an attorney probably somewhere, I would say, in the range of either $1,500 up to $2,000 for that fee, but then once the house is sold, she has to make sure that reverse mortgage gets paid off.
Absolutely.
She probably was left with very little proceeds at the end.
Absolutely. The house was eventually sold off, but the other problem she had is that, and I knew her father quite well, the other problem she had is that she found out later that her dad's brand new vehicles, every year he would get a brand new vehicle, and he would do that by leasing the vehicle. Well,
sure.
The car company that he leased the vehicle from would not take it back.
Mm-hmm. Yeah, that happens sometimes. And so, again, when you're entering into any kind of a contract, leasing a vehicle, etc., you want to talk to whoever you're leasing it from about what happens if I pass away, right? And so the different dealerships will have different rules. Sometimes they're very willing to work with the family. They're happy to take repossession of the vehicle, terminate the lease. But sometimes they're not, and sometimes it's going to be a little bit difficult to be able to turn that vehicle in, even though there's nothing you want more, right? I just want to give it back, be done with the payments. Sometimes it's not that easy. And there are instances where, like for Cindy, for instance, if the car company really refuses to take the lease back, she may have to be appointed through a probate proceeding on behalf of her father's estate to then work with that car company to turn in the vehicle. So sometimes it's even more hurdles than you would have expected.
That's exactly what happened to her, too. And that's not all either. Reversed mortgage, right? That's what we're talking about. Her father didn't really take care of what he had to do on the house. As an example, the township forced people to raise their chimneys by 1 foot, and he never did that. And then she was facing that problem as well.
Oh, boy. Absolutely. I mean, when you're selling real estate, whether it's your own or you're selling someone else's real estate after they've passed away, through that process and through the inspections and all of those things, you can discover that some things have fallen behind and need to be updated before the property can even be sold. So, yeah, I feel bad for Cindy because it sounds like she's encountered all of the bad things in a probate proceeding. That's just to note that they don't all go as terrible as Cindy has experienced. It's just that she must have drew the short straw there.
Well, you know what? The father never told his daughter that he had a reversed mortgage. So, lo and behold, when he passed away and she found all that out, it was like a real shock to the system, you know?
Sure, absolutely.
And that's why it's very, very important that families get together and disclose everything so that the executor of the last will and testament knows exactly what he or she is getting themselves into. Isn't that correct, Megan?
I absolutely agree. I get calls all the time from people who say, my loved one passed away and I'm really not sure what steps to take. I'm assuming I have to contact an attorney. And we start to talk about what assets they believe to exist, but also what debts they believe to exist. And every once in a while, in speaking with an individual, we find out that the estate is what's called upside down, right? So there's more debt than there are assets. And sometimes the recommendation there is maybe you just walk away from the estate, because if you go through the hassle of getting appointed, which is very long and can be pricey, through this probate process, just to find out that you did all that work and there won't be enough assets to distribute beyond paying off the debts, sometimes it's not even worth going through with the proceeding. So every once in a while that does happen where there's too much debt and it doesn't warrant going through the estate proceeding.
Can you just do that? Throw your hands up in the air and walk away?
Sure. No one's obligated to go through that probate proceeding.
And there's no legal repercussions if someone does that?
No, not at all. I mean, the creditors will have an opportunity to pursue the proceeding themselves so that they can recoup some of the money that they are owed. But rather than a loved one, an individual, going through the hassle just to pay off these creditors, sometimes their decision is fine. If the creditors want to go through it whenever they're ready, they can put out the money to have their lawyers do the paperwork, spend the time, the aggravation, and ultimately they'll be able to collect what they need to collect.
Wow. Megan, you are so good, and you're also a partner there in that law firm. You need a good attorney to help you through.
That's true.
You needed a good attorney to help you through the jungle with all of this. That's darn
right.
sure.
I think that's a great way to describe it. It can be a jungle. It's an area that people never deal with until suddenly they're thrown into it, right? Someone that they know and love has passed away, and now they're experiencing this jungle, this really difficult scenario. And I think you're right. You really do need an attorney to help you navigate that. Also a good accountant, a good financial advisor. You need some professionals who deal in this world to guide you.
How about more of your contact information, please, Megan?
Absolutely. The phone number at the office is going to be 845-291-0011. The website is www.mid-hudsonlaw.com.
Now, you're located in Goshen, right?
Yes, our primary office is in Goshen, 10 Matthew Street in Goshen. We do have a satellite office in Monticello as well, so for our Sullivan County folks, that is an option. We can meet you in Monticello, too.
Wow. So having a consultation with you in regards to this reversible mortgage and all these different changes in the year of 2026, about how long does that take?
The meeting itself?
Yes.
So I block out 90 minutes, an hour and a half, so that At that first meeting we have plenty of time to talk about all of the questions that people will have and really start to strategize, come up with a couple of options to address their major concerns, really start to plan out what are some of the things that they can be doing at home on their own and then also through an attorney so that they can get their estate plan in order.
Wow, that is awesome. 90 minutes, huh?
Yeah, and sometimes it really takes right up to the 90-minute mark. There's people that have a lot of questions. Like you said, this is a jungle. This is an unknown area, and they hear things, right? They talk to friends, and they get little bits of information, and they just want to know the real story. So 90 minutes we feel is appropriate.
So let's go back to the new year right here of 2026. If you could please reiterate some of the changes for the last will and testament, capital gains, taxes, all of that again, that would be very, very helpful information.
Absolutely. So at this point in the year, the changes that we are seeing, so this is confirmed changes, are mostly to the estate tax exemption levels. We've seen them increase a little bit from last year, and that is the trend. Typically, they'll increase a little bit to account for inflation. So for New York State, you don't have to pay an estate tax if your estate is below $7.35 million. And for federal estate taxes, you don't pay an estate tax if your estate is below $15 million. So for a lot of us, that frees us up to focus on other things like long-term care Medicaid planning, capital gains tax planning, and really just focusing on our family and making sure our stuff gets to the right people.
So if your estate is worth more than $7.5 million, what's the percentage of tax you have to pay on that?
Could be up to, I think, about a 16% tax. Not exactly sure on the highest number. It depends, but I think it's about a 16%.
Wow. That's a lot. It could be a lot, right?
It's a lot. Can be a lot. Could be a huge chunk of the estate. And so where we find that some people will have problems with that is going to be that if a lot of their estate is in a business or if it's in real estate, something that's not readily liquid, especially if they want the family to continue that business or hang on to that real estate, then the family's going to have a hard time figuring out, where do I pay this estate tax from now if all of the assets or a bulk of the assets are not liquid? So we really don't want to leave them in that kind of a position. We certainly want to do planning to reduce any estate taxes, which you can do, by the way. If you're above the exemption, through proper planning, you can reduce and even eliminate estate tax. But even if we're going to go ahead and pay the estate tax, we want to make sure there's enough liquid funds available to do that.
So if it's a profitable business and it's worth $10 million and somebody's going to take over the family business, that's still 16% tax on that?
Yeah, so they look at the total value of all of the assets. So if a business is included as part of those assets, still an appraisal would be done at that time, a business appraisal, to determine what the value is. But it's not just the business, right? It's did that person also have a primary residence, because that's going to get valued in. They have regular checking, savings, investment accounts. The value of life insurance gets counted in there, retirement accounts.
Wow.
So any asset that they had at the time they pass away, all of that has to be valued. Then we look at the total value of all of those assets, determine if they exceed the exemption level, and then the percentage of estate tax gets applied across the board to the total value.
Amazing. So they take everything into account.
Oh, yeah.
Wow, I didn't know that. Megan, your contact information again, please.
Yes, so the firm is Blustein, Shapiro, Frank, and Barone. We're in Goshen. The phone number is 845-291-0011, and the website is www.mid-hudsonlaw.com.
So next weekend you have a webinar, yes?
Yes, it's actually on the 27th, which is Tuesday. In the afternoon, we have a webinar. If you want to sign up for that webinar, it's unlimited seating. You can just go right on our website, sign up by entering your contact information and an email address. It's completely free of charge, open to the public, and it's just an opportunity for me to tell everyone a little bit more about estate planning in general.
About how long does the webinar last, Megan?
It's about a 2-hour webinar.
Oh, okay. And there you go over everything with a fine-tooth comb, right?
That's right.
All right. So, Megan, Happy New Year to you.
Thank you. Same to you.
Thank you very much. And I'm glad you had a wonderful holiday. It was all
I did, and I really hope you enjoyed yours.
Oh, very peaceful, and it was all about the food.
That's great. That's the way it should be.
Absolutely. And New Year's Day, too, was all about the food. Oh, I love good food, Megan. I really, truly do.
Same here.
Megan, thank you so much for your valuable time, as always, and it's wonderful having you here with Planning Ahead.
Happy to be here, Bobo. Have a good one.
Yep, until next time, my friend. There she goes, Megan, elder law attorney. You need to check her out, and that webinar, too, as well. I have more of the greatest music ever recorded on the way next, right here on Oldies 98.9, 105.3, WGNY FM.